Someone who serves like you doesn't deserve to touch this heirloom. Get out.
Leave the tray exactly where it is. When this case closes, only one woman at that counter will still be free.
4:32 in the afternoon on the last Saturday in March in the private viewing room at Verlaine and Kestrel on Michigan Avenue, Amara Holloway entered the final weight of a Kang family diamond into a leather intake ledger. Vivian Kong lifted the ring off the velvet, turned it once under the light, and set it down with a small, definite click. Nobody noticed the second velvet tray already waiting beneath the register, a loop resting on it that was not the one Amara had used all afternoon. Across the room, a man in a charcoal suit set down a watch he had only been pretending to examine and did not move again. Before this goes any further, tell me where you are watching from tonight and what time it is where you are. Stories like this one land differently depending on how many hours of your day are already behind you. If you have ever been the person a room decided not to see, drop your city below, because the ending of this one belongs to you as much as it belongs to Amara. Now, back to the counter at Verlaine and Kestrel, 4:32 in the afternoon, the last Saturday in March, where the ring had already changed hands twice. Vivian Kong was the only person in that room who thought the matter was finished. Amara did not raise her voice, and she did not reach for the ring. 6 years behind a jeweler's counter had taught her that arguing in front of witnesses was the fastest way to look guilty. She set her loop down on its pad, folded her hands on the edge of the table, and watched Vivian hold the stone to the light a second time as if daring anyone to contradict her. Behind Vivian's on a low shelf near the private door sat a small framed photograph the family kept beside every appraisal folder. It showed an elderly woman in a hanbok who had worn that same diamond for 40 years before Vivian ever touched it. Vivian treated the photograph the way other people treated scripture, and she had said more than once that the ring answered to the family before it answered to anyone wearing it. Patricia Vance, the branch manager, came around the counter, fast, the particular speed of someone who had spent that morning on the phone with a Meridian Standard board member. She did not ask Amara for her version of events before asking her to clock out for the day. The 12 clients along the north cases did what wealthy people in a jewelry store tend to do when a scene erupts nearby, which was to keep browsing while listening to every word. Vivian slid the ring into a chamois pouch she produced from her handbag with the ease of a woman who had already decided exactly where it would go. She thanked Patricia for her discretion in a voice pitched to carry across the room. Grant, who had been checking his phone by the door since his mother sat down, did not look up until she was already walking toward him. Even then, he only asked if she was ready to leave. Amara collected her tools from the tray, with hands that did not shake because she had promised herself years ago that she would never again let anyone see her hands shake. She zipped her loop into its case before she said a single word to Patricia. The man in the charcoal suit had not moved through any of it, and when Amara passed him on her way to the back room, he did not look at her either. She noticed and did not have the energy to wonder why. Patricia followed her as far as the swinging door and explained in the tone reserved for policy, rather than people, that this was standard procedure whenever a client raised a concern about missing merchandise. She would be in touch once the matter was reviewed. In the back office before she clocked out, Amara opened the intake system one last time and pulled up ticket number 4412, logged at 3:19 that afternoon. It listed the stone's weight, its color grade, and the 10-digit inscription she had checked under magnification against the original certificate on file. She was not thinking about proving anything, yet only about the small, stubborn habit of a woman who had learned early that paperwork disappeared faster than people liked to admit. She forwarded the ticket to her own personal email before she logged out a routine she performed for every intake and had never once needed until now. She did not print anything, did not tell anyone, and did not mention it to Patricia on her way out. The only thing she was certain of at 4:51 that afternoon was that a stone she had personally verified an hour and 32 minutes earlier did not turn into a different stone on its own. A folding table in a church basement in Gary, Indiana, once held 11 pieces of jewelry from a marriage that no longer existed. A 14-year-old Amara Holloway watched her grandmother sort through them under a single hanging bulb, deciding which ones could still be sold. Corinne Holloway had raised her granddaughter alone since the spring. Amara turned 12 the year Amara's mother left for a job in Ohio that was supposed to last 3 months. It never once produced a phone call, and Corinne had never described that arrangement as anything but permanent from the day it began. Money in that house was counted, not estimated. The ring that kept the lights on that winter was a 2-carat solitaire. A pawnbroker, 3 towns over, valued at $400 a figure, Corinne accepted without argument because she did not know enough to ask for more. 11 months later, in a library book with a cracked spine, Amara first read the words, loop inclusion and refractive index. She understood with the particular fury of a smart child who has just been shown how she was cheated that the stone in that ring had been worth closer to $6,000. She did not tell her grandmother until she was 23 and had already passed her graduate gemologist examination. By then, the only thing she wanted to give Corinne was proof that the debt had been repaid in a currency nobody could talk her out of again. Corinne kept every graduation photograph, every certificate, and the original library book, its spine reinforced now with packing tape on a shelf in her front room in Gary. She told anyone who visited that her granddaughter could look at a stone and tell you exactly what it had lived through. By the time Amara moved to Chicago for the position at Verlaine and Kestrel, she had built a private rule she never said aloud to a client. Nobody who sat across her viewing room table would ever leave believing they had been told less than the whole truth about what they were holding. The graduate gemologist program at the Gemological Institute of America taught Amara to grade a diamond the same way every time, regardless of who was watching. She started with weight to the 100th of a carat moved to color under a masked fluorescent booth, calibrated against a master set and finished with clarity under 10 power magnification in a darkened loop well. She still followed that order 6 years into her career, even for regulars who wanted her to skip straight to a number. She had watched too many colleagues shortcut the process and miss a fracture filling that only showed itself when the light hit a stone at exactly the wrong angle. Verlaine and Kestrel required every incoming heirloom to be logged against its original paperwork if any existed. Amara had added a second habit: the store did not require photographing the girdle of every diamond under her scope before recording its report number. The step took 90 extra seconds, and it had never once been necessary until the last Saturday in March. Her supervisors called her thorough in performance reviews, a word that always arrived paired with a small laugh, as though thoroughness in a gemologist were a charming personality trait rather than the entire point of the profession. Amara had stopped correcting them out loud sometime around her second year. The store's insurance carrier required a written appraisal for anything over $10,000, but Amara wrote one for anything over $2,000. She had set that threshold for herself the year a client's estate lawyer called asking for documentation on a ring the store had graded verbally and never logged. She kept her own loop, a 10-power triplet with a scratch on the rim from a night class in Gary, rather than use the store's shared equipment. A scratch in a known place told her instantly whether a stone had shifted position under the lens. Every report she filed carried her initials in the same corner and the same size. A habit a professor at Jai had once called compulsive, and Amara had never once seen a reason to change. 6 years earlier, on the Tuesday morning with the store nearly empty, a man in an unremarkable gray overcoat set a loose diamond on Amara's tray. He asked her without introducing himself to tell him what was wrong with it, since 3 other appraisers that month had told him nothing was wrong with it at all. Amara turned the stone under her loop for 11 minutes without speaking long enough that the man shifted his weight twice. She told him the stone had been clarity enhanced with a glass fill along the pavilion, a treatment that lowered its value by roughly 60%. It would show as a flash of orange or blue if he ever tilted it under a single strong light. He asked how she had caught it when 3 graduate gemologists had not, and she told him the truth. Most appraisers were paid by the transaction and had learned not to ask questions that slowed a sale down. She had never once found that trade worth making. He gave her a business card with only a first name on it. Daniel, no last name, no title, and told her he would be sending more stones her way. For the better part of 2 years, he did exactly that, always alone, always early in the day, addressing every question to her and no one else on the floor. It was Patricia, not Daniel, who eventually mentioned in passing that the quiet man who only ever wanted Amara's opinion held a controlling stake in the company that owned the store. The information changed nothing about how Amara treated him, because she had already decided the only thing worth impressing him with was the same accuracy she gave every client. Daniel never once used his position to shortcut her process, and never asked her to grade faster or friendlier for a client he was courting. It was that single fact repeated across dozens of quiet Tuesday mornings that taught Amara to trust him before she ever learned what he was actually worth. He never asked to see her personal notes, and he never once commented on anything beyond the stone in front of him, a restraint Amara noticed precisely because it was so rare among the men who came through that door. The last stone he brought her 8 months before the last Saturday in March was a pale yellow diamond. he said, had belonged to a business partner's family. Amara had graded it fancy light yellow vis clarity without asking why a man with no wedding ring kept bringing her other people's heirlooms. She had her own theory about that one she never said aloud either. What Amara did not know, walking out of Verlaine and Kestrel at 4:53 that afternoon, with her certification suspended pending review, was that Daniel had not been standing at the North case by accident. He had been in that branch for 6 consecutive Saturdays reviewing a discrepancy in the chain's inventory reconciliation. The discrepancy kept returning quietly and repeatedly to a single family name. Until 4:32 that afternoon, he had not yet connected that name to the woman he had trusted with every stone he owned. 3 weeks into her suspension, Amara was still doing appraisal work, though not through Verlaine and Kestrel. A private collector named Marcus Ueda, who had used her services twice before through the store, tracked down her personal number and asked her to authenticate a parcel of loose stones for an estate sale. The parcel held 19 stones, mostly small. Amara spent 4 hours at her kitchen table grading each one individually rather than estimating the lot as a whole, a method Ueda later told a friend he had never seen another appraiser bother with. The job paid more in one afternoon than 2 weeks of her store salary combined. She did not know, and had no way of knowing, that Marcus Ueda had been given her name by Daniel, who made exactly one phone call and never mentioned it again. The entire point of the referral was that it could never be traced back to him without both of their reputations suffering for it. Vivian Kong learned about the Ueda appraisal at a luncheon where another woman mentioned admiringly that the gemologist from the Kang scandal had somehow landed a client worth more than most people's annual salary. Vivian set down her water glass with the same small definite click she had used on the ring 3 weeks earlier. She had expected Amara to disappear into a lesser job somewhere quiet and stay there. The fact that a woman she had publicly accused of theft was instead being sought out by name told Vivian that the loss prevention review was moving too slowly for her comfort. That evening, she called a Meridian Standard board member she had known socially for 11 years, a man she had once helped seat at a charity gala beside a senator's wife. The company's compliance line automatically recorded every call after the greeting each caller heard before being connected a greeting Vivian had never once listened to past the first 4 words. In the same voice she had used at the counter, she asked him to make sure the review reached the correct conclusion before the end of the month. She reminded him almost as an afterthought that the Kong family's annual purchases at the flagship store alone exceeded $200,000. I told her he would look into it personally, a phrase Vivian had heard often enough in her life to know it meant exactly what she wanted it to mean. The correct conclusion arrived 9 days later in a letter from Meridian Standard's Human Resources Division. It informed Amara that her badge access was suspended indefinitely, her salary withheld, pending an active loss prevention investigation, and her personnel file flagged in a way that would surface in any reference check a future employer might run. The letter did not name Vivian, and it did not need to. Amara recognized the phrase, active loss prevention investigation, from the moment she read it, the same words Patricia had used standing in the office doorway 3 weeks earlier. Grant called her twice that week, each call lasting under 4 minutes, and both times he opened by saying his mother meant well. Amara had started to notice he reached for that sentence whenever he wanted to avoid naming what his mother had actually done. Both times she let the call end without agreeing or disagreeing with him, and both times she wrote the date and duration in a notebook she had started keeping on her nightstand. The engagement itself was not formally over, not yet. The wedding deposit the two of them had put down on a venue in Evanston, $14,300, split evenly between them, was frozen that same week under a clause Amara did not remember signing. It allowed either family to pause the contract, pending in the venue's own language a change in the couple's circumstances. Amara read that clause 3 times at her kitchen table before she understood what had happened. Someone, likely Vivian's own attorney, had submitted the pause request using Grant's signature and a copy of the Human Resources letter as supporting documentation. All of it moved through channels Amara had no access to and no standing to challenge from where she sat. Her employee badge, which had opened the staff entrance on Wabash every weekday morning for 6 years, returned an error tone the following Monday. It was a flat double beep she had only ever heard before on badges belonging to employees who had already left the company. The store's scheduling software quietly removed her name from the following month's calendar without sending the automated notification it usually sent for a shift change, a silence. Amara only noticed because she still checked the schedule out of habit. Amara did not call Grant about the venue deposit, and she did not call the number listed on her suspension letter. Both of those conversations would happen on someone else's schedule and someone else's terms, and she was done operating on anyone's terms but her own. Instead, she opened a folder on her laptop labeled with the date of her suspension and began adding to it the way she had been trained to document a disputed stone. She started with a time-stamped copy of every email Patricia had sent her, every text from Grant, and a personal log of every call written the same evening it happened, while the details were still exact. She requested a formal copy of her own personnel file through the employee portal rather than through Patricia, directly a right. Every Meridian Standard employee had on paper, and almost none of them exercised. The portal confirmation email quoted company policy back at her stating the request would be fulfilled within 30 business days. Amara wrote that number on a sticky note and pressed it to the edge of her monitor so she would know exactly when to follow up. The file arrived 19 days later with several pages referencing an earlier incident report Amara had never seen and had never been told existed. The report, dated 4 years before Amara had even started at the company, described a discrepancy at the chain's Oak Brook location involving a Kang family piece, a sapphire and diamond bracelet brought in for a clasp repair. A clerical note closed the matter as an inventory counting error, no further action required, signed by a store manager who no longer worked for the company. Amara compared the handwriting out of instinct against 3 other documents in the same folder. Amara read it twice, then a third time, circling the words Kong family piece with a pen. Whatever this was, it was not the first time a stone belonging to that family had gone missing from a Verlaine and Kestrel counter. The store's own paper trail had quietly closed the door on it once already. She did not know yet what to do with that report, only that it belonged in the folder next to the suspension letter and the frozen venue contract, now 4 documents, deep and growing. For the first time since the last Saturday in March, she felt something other than the specific tired anger of a person waiting to be believed. The Oak Brook incident report was missing, its appraiser's signature line a gap every closed loss prevention file at the company was required to carry. Amara noticed only because she had spent 6 years initialing that exact line herself on every intake she processed. She requested the underlying appraisal ticket connected to that report, expecting a routine delay. Instead, she received an automated message stating that the ticket number referenced in the file did not exist in the current system, though the report citing it clearly did. The store's intake system, she knew from 6 years of using it daily, archived closed tickets rather than deleting them, moving them to a read-only folder after 90 days rather than erasing them from the database entirely. A ticket that had been closed, cited, and filed away could not simply fail to exist 4 years later unless someone had removed it after the fact. That kind of deletion required a level of system access only a handful of people at Meridian Standard actually held. Amara sat with that thought longer than she sat with almost anything else in the folder. A missing ticket was not a clerical error. It was a decision someone had made on purpose. The second strike arrived at Grant's sister's engagement dinner, held in a private room at a hotel on East Walton, with 40 place settings and a single long table dressed in white. Amara attended only because canceling would have looked in Vivian's careful arithmetic like an admission of guilt. Vivian had brought the family's small traveling shrine that evening, a folding frame no larger than a hardcover book, holding the same photograph of the elderly woman in the hanbok. She set it on a side table near the gift display without explaining why to any of the caterers who asked. Partway through the evening, Vivian leaned toward her sister-in-law and switched to Korean the way she did whenever she wanted to say something in front of someone she had decided did not need to hear it. She said that a woman like Amara had no business near a family altar photograph that had outlived 3 generations of Kang women, and that the diamond had been meant for a granddaughter-in-law who understood what it cost to keep a family's name clean. Amara kept her expression still and went on cutting her food because 3 years of Tuesday night classes at a community college on Argyle Street had taught her enough Korean to catch most of it, more than enough to catch that sentence in full. She said nothing and filed it away with everything else she was collecting, the same flat attention. She gave a stone that had already told her everything it was going to tell her. Vivian used the toast delivered over the entree course to 40 guests to announce that the family had decided to postpone Amara and Grant's wedding, indefinitely, citing what she called ongoing concerns about trust. She did not say the word theft out loud, likely on her attorney's advice, But she did not need to. Every guest at that table had already heard some version of the Michigan Avenue story, secondhand retold with the embellishment that travels faster through a social circle than any correction ever could. 3 of Amara's private clients canceled standing appointments within the following week together, worth just under $9,000 in appraisal fees she had already budgeted toward her own half of the wedding costs. 2 cited scheduling conflicts, and 1 simply stopped communication entirely, leaving a voicemail that thanked her for her past work in a tone reserved for people who did not expect to call again. Amara understood without being told that Vivian's social reach extended further into Chicago's collector community than 6 years of careful, accurate work ever had. Grant said nothing during the toast, and he said nothing after it either, standing beside his mother while she accepted congratulations on her discretion. The guests assumed correctly that discretion in that family meant containment rather than honesty. Amara left before dessert, and in the parking garage, she sat in her car for 4 minutes without starting the engine. She was not crying, only recalculating because the second strike had told her something the first one had not. Vivian did not intend to let this end quietly, and neither Amara decided would she. What Amara still did not know was that Daniel's 6 Saturdays of inventory review had already led him to the same missing Oak Brook ticket weeks before she ever requested her personnel file. The reconciliation discrepancy he had been tracing across the chain's 21 locations kept returning to a single pattern. A heirloom piece was logged, then unlogged, then quietly written off, always somewhere near a Kang family transaction. He had not yet told anyone at Meridian Standard what he suspected, and he had not told Amara either. An accusation built on a hunch was worth nothing against a family with Vivian Kang's, standing a family whose combined purchases across the chain's 21 locations had totaled just over $3 million in the past decade alone. Daniel had cross-referenced that figure himself, printed on a spreadsheet he kept in a locked drawer at home, rather than on any company server because he did not yet trust the company's own systems to keep it private. Daniel had learned a long time ago in a house very different from a jewelry store exactly what it cost to move against someone before the proof was undeniable. It was the personnel file request, logged automatically in the same employee portal Daniel had access to as a matter of corporate oversight, that told him what Amara had found. She had pulled her own record and requested the underlying ticket for the Oak Brook report, and he understood immediately that she had found the same gap he had spent 6 Saturdays circling from the outside. He did not call her, and he did not send a message through any of the anonymous channels he had used for Marcus Ueda. He recognized watching her request move through the system. One careful step at a time, a woman building a case the same way she graded a stone in the correct order without shortcuts. The portal logged timestamps for every action a user took, and Daniel could see that Amara had submitted her personnel file request at 6:15 in the morning, before her suspension letter had even finished printing at the branch, a detail that told him she had anticipated the letter before it arrived. He had already decided months earlier that the day he interfered directly would be the day he stopped trusting her judgment. Instead, he opened his own file, the one he had been keeping since the first Saturday. He noticed the reconciliation discrepancy. A plain manila folder with no label kept in the bottom drawer of a desk his assistant was not permitted to organize. He began cross-referencing it against every document Amara's request had touched, working from his office at 11 at night, with the patience of a man who intended to make exactly one move and needed it to be correct. On the following Monday, Daniel exercised the authority of his controlling stake in Meridian Standard Holdings for the first time in 3 years. He instructed the company's IT division through a formal written request rather than a phone call to preserve all security footage from the Michigan Avenue branch for the full 90-day period surrounding the last Saturday in March. This overrode the automatic deletion schedule that would otherwise have erased it within the week. He then requested as a board member, rather than as anyone with a personal stake in the outcome, that the loss prevention investigation into Amara Holloway be reassigned to an outside auditor rather than resolved internally. The request needed no explanation beyond the missing Oak Brook ticket, which he attached to it in full, along with a 2-paragraph memo listing every date the ticket had been accessed before its deletion. The board member. Vivian had called 11 days earlier, pushed back once mentioning that the Kang family had been loyal clients of the chain for over a decade and had personally underwritten a wing of the Art Institute 2 years prior. Daniel replied only that loyalty was not the question in front of them. The missing ticket was, and asked whether the board member preferred to explain that gap to outside counsel himself. The board voted 6-1 to approve the outside review, the single dissenting vote belonging to the member who had taken Vivian's call, and the vote was recorded in minutes that would later become part of the same file outside counsel used. Daniel also directed the company's general counsel to retain a forensic accounting firm the company had used twice before on an engagement letter that named the audit's scope only as chain-wide loss prevention irregularities, a phrase broad enough to cover both branches without naming a single person. Nobody on the board asked Daniel why he was pursuing a routine personnel matter with this degree of personal attention. Daniel did not offer an explanation because the honest one was not a sentence he was prepared to say out loud in a boardroom. He trusted exactly one gemologist in the entire company, and he refused to watch her lose everything over a stone she had graded correctly. Daniel had not spoken to his father in 4 years, not since the dinner where he said he would not be taking over the family business. His father, the founder of a shipping and logistics conglomerate, 3 times the size of Meridian Standard, received the news in silence for the length of an entire course. Then he asked in Korean whether Daniel understood what it meant to be the first son. His younger brother took the position instead, a fact their mother mentioned at every family gathering. Daniel still attended, always framed as a compliment to his brother, rather than a complaint about Daniel. Everyone at the table understood it as both. Daniel remembered the exact week at 9 years old when his father stopped correcting his brother's mistakes at the dinner table and started correcting only his, a shift so gradual that Daniel had not understood its purpose until he was nearly 20, when a family friend explained that a first son was groomed and a second son was simply loved. He kept a single photograph from that period himself, at 12, in a school uniform, standing a full step behind his father at a shipping terminal ribbon, cutting a print he had never framed and still could not throw away. The one tradition Daniel still kept was his mother's birthday ritual, a bowl of seaweed soup made every year on the anniversary of his birth, rather than hers, honoring the mother's labor rather than the child's arrival. He had eaten it alone in his apartment for 4 years because showing up at his parents' house meant sitting across from his father's silence for 2 hours over a bowl of soup neither of them would mention. He had built Meridian Standard from a single struggling jewelry chain his father once considered beneath the family name. Buying his first 2 locations with a personal loan he had spent 6 years repaying before he ever bought a third. He had done it quietly without his father's investment or approval, because the only inheritance he had ever wanted was proof that competence did not require a birthright to be real. That belief made watching Amara's suspension letter arrive feel less like sympathy and more like recognition. The particular recognition of watching someone else get punished for being correct rather than for being wrong. Daniel visited the Michigan Avenue branch on a Wednesday a day. Amara was not scheduled to work and could not have known he would be there. He stood for a long time at the case nearest the private viewing room, looking at nothing in particular while a junior associate hovered a few feet away, unsure whether the silence meant she should offer help or leave him alone. Then he asked Patricia in the flat tone he used for every store visit to pull the full Oak Brook file and have it couriered to outside counsel by Friday. Patricia had spent 3 weeks assuming her handling of the Amara situation would never be questioned by anyone above her direct supervisor, and she did not ask why. Something in the way, Daniel said outside counsel told her this was no longer a conversation she had any authority in, and her hand, Daniel noticed, had gone still on the folder she was holding. On his way through the showroom, Daniel paused at the case where Amara's intake ledger was normally kept and found it still in its usual place, undisturbed exactly where she had left it on the last Saturday in March. He did not open it. On his way out, Daniel stopped at the employee schedule posted by the back office door and found Amara's name struck through in red for the current pay period. He stood in front of it exactly as long as it took to memorize the date her suspension had begun, then left without asking to see her personnel file, because he already knew what was in it. A junior manager offered to walk him out through the front, and he declined. Taking the same side door Amara had used on the last Saturday in March, though neither of them ever compared notes on that afterward. Amara found the recording by accident, or as close to accident as 6 years of careful habit allowed. She called the Meridian Standard compliance line herself to formally dispute her suspension and was placed on hold for 22 minutes, long enough to hear the automated greeting twice. The greeting stated that all calls were recorded for quality assurance, a sentence she had heard 100 times without once considering what it meant for a call placed to that same line 11 days after her suspension began. She submitted a formal records request under the company's employee data policy, the same policy that had produced her personnel file, asking for any recorded calls referencing her name or badge number. The request form had a field for date range, and she filled in the 11 days following her suspension letter, a guess based on nothing more than her own sense of how quickly a woman like Vivian moved once she wanted something settled. 3 weeks later, far past the 10-business-day window, the policy itself promised a compliance officer she had never spoken to forwarded her a single audio file with no explanation, beyond a case reference number 7 digits long that matched nothing in Amara's own folder until she cross-referenced it against the date on her suspension letter. She listened to it once at her kitchen table at 11 at night, with her grandmother's old library book sitting closed beside her laptop the way it had sat on her desk through every exam she had ever taken. She did not need to listen a second time to know exactly what she was holding. The call confirmed what the missing Oak Brook ticket had only implied, a voice Amara recognized from a jewelry store viewing room, asking a board member by name to make sure a review reached the correct conclusion. Amara forwarded the file to outside counsel the following morning with a 2-line message and no further explanation of her own. 11 days later, a letter arrived scheduling a formal review meeting at the Michigan Avenue branch in the same private viewing room at 4 o'clock in the afternoon on the second Saturday in June. Among the parties required to attend, the letter listed Vivian Kang, printed in the same plain font as every other name on the page, with no indication of what that Saturday would actually cost her. The private viewing room at Verlaine and Kestrel looked exactly as it had on the last Saturday in March. The same velvet trays, the same recessed lighting, the same leather ledger closed on the corner of the table. Amara sat in the same chair she had occupied that afternoon, though this time a folder sat in front of her instead of a stone, and outside counsel sat to her left instead of nowhere at all. Daniel sat at the head of the table, introduced to the room by his full title for the first time in 6 years of Amara knowing him, controlling shareholder of Meridian Standard Holdings. Patricia repeated this title twice, as if she still did not quite believe it, applied to the quiet man who used to stand at the North case on Tuesday mornings. And she had spent the previous evening reviewing 6 years of his visits in the system, finding nothing more suspicious than a man who always paid for parking in cash. Vivian arrived 4 minutes late, dressed for what she clearly expected to be a formality, and took the same seat she had taken in March. She set her handbag on the table with the composure of a woman who had never once lost a room in her life. Amara had spent the morning laying out her tools on her own kitchen table, not because she would need them, but because arranging a loop and a scale in a straight line had always steadied her hands before anything that mattered. She left them at home in the end, deciding that the folder in front of her now did the same work a loop once did, only at a distance no one in this room could argue with. She opened by thanking Daniel for personally overseeing what she called an unfortunate misunderstanding. She suggested in the same pleasant carrying voice she had used in March that the store's continued employment of someone under active suspicion reflected poorly on Meridian Standard's judgment rather than on her own. She implied, without stating it outright, that Amara's presence at the table was a courtesy the family had not requested. In under 2 minutes, she managed to remind the room that she had arrived expecting an apology and a settled matter, not a review. She added, glancing once at the leather ledger still closed on the corner of the table, that some families kept better records than others, and that record-keeping in her experience said everything about a person's character. Grant, seated beside his mother, said nothing, and Amara noted with the same flat attention she gave a stone under magnification that he had not once looked at her since walking in. He had, she noticed, loosened his tie twice in the first 3 minutes, a habit she recognized from every difficult conversation they had ever had. Outside counsel opened the folder and set 3 items on the table, in order sliding each one so it faced Vivian rather than the room. It was the way Amara had learned to present a disputed stone to a client, so they could see it clearly rather than be told about it. The first was a single printed page, the intake ticket for number 4412, dated the last Saturday in March, still carrying the faint toner smell of a printer that had run it off that same morning. It listed a weight, a color grade, and a 10-digit laser inscription number. Amara had copied from the girdle of the stone at 3:19 that afternoon, 90 minutes before the ring reached Vivian's hands. Beside it sat a second page, a still frame pulled from the branch's overhead camera, time-stamped 4:31 and 11 seconds, showing a hand closing around the tray a full 60 seconds before Vivian ever lifted the ring to the light. The second was a thin gray folder 4 years old, its corners softened from handling, containing the Oak Brook incident report. Clipped behind it was a newly located appraisal ticket, recovered from a backup server. The original system administrator had forgotten existed, its printout, still showing the server's internal file path along the header. It showed a laser inscription number that did not match any diamond ever formally logged as sold, lost, or replaced. The third was a single sheet listing a case reference number and a runtime of 1 minute and 40 seconds, with no further explanation printed beneath it. Outside counsel did not intend to explain it yet. Outside counsel began with the numbers, walking the room through the 10-digit inscription on file for the Kang heirloom, the same number Amara had recorded at 3:19 that afternoon. Then came the CZ replica store security had recovered from evidence storage, a stone with no laser inscription at all. It was a detail no amount of family history or social standing could argue against under a microscope. Vivian said the CZ had been planted, that Amara had swapped the stones and was now covering the theft with fabricated paperwork. Outside counsel asked her if that were true. Why the still frame from the overhead camera showed her own hand closing around the tray a full minute before Amara ever reached for it again that afternoon. Vivian did not answer that question and asked instead to see the camera's full, unedited footage rather than a single frame, a request outside counsel had already anticipated and answered by sliding a sealed drive across the table along with a printed chain of custody log. Outside counsel let her finish, then moved to the second item, the Oak Brook file and the ticket deleted from the active system 4 years earlier, but never fully erased from the backup server. That ticket connected to a different Kang family heirloom that had also gone missing during a routine cleaning and reappeared weeks later. It was valued $12,000 lower than its original appraisal. The difference never explained or investigated at the time. The store manager who signed that closure, outside counsel noted, had left the company 8 months after signing it with a severance payment that exceeded her contractual entitlement by an amount that had never been explained in her personnel file either. The pattern, outside counsel said, was not an accusation. It was an arithmetic problem. 2 heirloom pieces, 2 unexplained substitutions, 4 years apart, both connected to appointments. Vivian Kang had personally scheduled and personally attended each appointment logged under her own name in the store's booking system rather than an assistant's. Both times, the store employee present at the counter had been formally suspended within 2 weeks while the matter quietly closed itself. Grant spoke for the first time since sitting down, asking his mother quietly whether any of this was true, and Vivian did not look at him when she answered that he would not understand business matters between families. Vivian's attorney, seated beside her for the first time that afternoon, asked to see the backup server documentation, and outside counsel provided it, sliding across a printed copy along with a notarized certification from the server's hosting company confirming the file had not been altered since its original creation date. Along with it came a written statement from the system administrator confirming the ticket had been manually deleted 11 days after the Oak Brook incident was closed. The deletion required credentials belonging to a store manager who had left the company 3 years earlier. That manager, when contacted, stated in a signed affidavit that she had been asked to close the file quickly by a member of the Kang family and had not questioned it at the time. Vivian's attorney asked for a moment to confer with his client, and outside counsel agreed, noting for the record that the recess began at 4:22. When the meeting resumed 6 minutes later, Vivian's attorney asked whether any of this had been shared with the Cook County State's Attorney's Office, yet a question outside counsel answered by stating that a referral was already drafted and would be filed that same afternoon, regardless of what was said in the next 10 minutes. Then outside counsel played the recording, 1 minute and 40 seconds of a voice. Every person in the room recognized without needing it named. It asked a Meridian Standard board member to make sure a review reached the correct conclusion before the end of the month. The recording ended, and for 11 seconds, nobody in the room said anything at all. The longest silence Amara had ever sat through in that building. The room went as quiet as it had been loud in March because there was no version of that sentence spoken in that voice that meant anything other than what it plainly said. Vivian did not ask to hear it again, and she did not offer an explanation. For the first time in the 4 years since the Oak Brook ticket disappeared, there was nothing left in the folder for her to argue with, and nowhere left in the room for the argument to land. A silence Patricia later described to a colleague as the longest she had ever sat through in 11 years at that branch. Patricia, who had not said a word since the meeting began, was the one who finally broke the silence, though she was not the one who chose to say it. Outside counsel asked her to read aloud the exact line recorded in the branch's incident log from the last Saturday in March, the line a witness had written down at the time. The log stated that Vivian Kang had told Amara she did not deserve to touch that heirloom and had ordered her to get out. Patricia read it once, set the page down on the table, face up in the same spot where the ring itself had once sat. Amara did not look at the page when it was read, keeping her eyes instead on the same spot on the velvet where the ring had sat that afternoon, because the sentence itself had stopped being able to reach her somewhere in the last 4 months, and she found she was more interested in whether Vivian's hands folded on the table would move at all. They did not. Nobody at the table asked what it meant that those words were now sitting in a file with Vivian's name attached to the misconduct. By then, the answer was already sitting on the table in front of all of them, 10 digits long and impossible to argue with. Outside counsel closed the meeting by stating for the record that Meridian Standard's findings, along with the recovered documentation and recording, would be forwarded to the Cook County State's Attorney's Office that same afternoon. 2 detectives from the 18th District, already waiting in the lobby at Daniel's earlier request, would need to speak with Vivian before she left the building. Vivian did not resist when the detectives approached the viewing room. She only asked her attorney quietly whether this meant she would need to reschedule a dinner that evening, a question nobody in the room answered. One detective read her the standard advisement in a flat, practiced voice, while the other collected the sealed evidence drive in the folder from the table, initialing a receipt that Patricia countersigned as branch manager on duty. Vivian was not handcuffed in the viewing room itself. A small mercy, the lead detective explained afterward, was standard procedure for a suspect who showed no sign of flight risk, though she was placed under arrest before she reached the elevator. The formal charges, when they arrived, 9 weeks later, listed theft of property exceeding $80,000 in insurance fraud, spanning 2 separate incidents. They were filed by the state's attorney's office, not by Amara Daniel or Meridian Standard. Directly exactly as outside counsel had explained it would work from the beginning, a distinction Amara found herself repeating to Corinne on the phone that same night more than once until she was certain her grandmother understood it. It was a process built on evidence, not on anyone's personal authority to punish. Amara's badge was reactivated that same afternoon, her suspension formally closed with a letter that used the phrase "no further action required" for the first time in reference to her. Patricia handed her the new badge personally, rather than mailing it through the usual channel, and said only that she was sorry. A sentence that arrived 4 months too late to mean very much, and that Amara accepted anyway because carrying the alternative felt heavier than letting it go. The wedding deposit. Still frozen under a clause she no longer had any interest in unfreezing, stopped mattering to her somewhere between the recording and the detectives. By the time she walked out of Verlaine and Kestrel that evening, she had already decided the engagement was not something she intended to revisit. Daniel walked her to her car the first time in 6 years. Either of them had done anything that ordinary together, and neither of them said much because for once there was nothing left that needed explaining out loud. Vivian Kang pleaded guilty 8 months later to a reduced charge of theft and insurance fraud rather than face trial on the full indictment. The plea required her to pay restitution of $96,600, covering both the Michigan Avenue heirloom and the Oak Brook piece from 4 years earlier in a single certified payment her attorney delivered to the court clerk 2 weeks before sentencing. She was sentenced to 18 months of probation with a no-contact condition naming Amara specifically, and a condition requiring 40 hours of community service at a legal aid clinic on the city's south side, an assignment the judge selected without explanation. The Kang family attorney requested the community service be served instead at a museum gala committee, a request the judge denied in a single line entered into the record. Grant did not attend the sentencing hearing. He sent Amara a single text message the following week, 4 sentences long, apologizing for his silence at the engagement dinner without once naming what he was apologizing for, and Amara read it twice standing in her own kitchen before deciding it did not require an answer. The engagement, never formally called off in writing, simply stopped being mentioned by either family sometime around the plea deal. That suited Amara, who had already returned the ring he gave her by courier 6 months earlier, with no note attached, and had received 2 weeks after that. A short handwritten card from Corinne that said only that some men needed a courtroom to learn what their mothers should have taught them at the table. A card Amara kept tucked inside the same book where she still kept her original GIA study notes. Meridian Standard offered Amara the newly created position of Director of Authentication for the full Verlaine and Kestrel chain. a role that placed her over the very loss prevention process that had once suspended her. She accepted it on the condition that every store in the chain adopt the girdle photograph habit she had kept privately for years, a condition the board approved without discussion, and one that added by the store's own later estimate close to 3 minutes to every heirloom intake across all 21 locations. She used that same 3 minutes to train 4 junior gemologists in her first year, each of them required to initial their own corner of every report, exactly the way she always had. Marcus Wada became a standing client rather than an occasional one, referring her to 2 other collectors within his first year of steady work with her. Within a year, Amara had built a private client list entirely on her own name rather than the store's of fact. She mentioned to no one except her grandmother. Corinne kept the news clipping about the Kang case in the same frame as Amara's original GIA certificate on the shelf in Gary that had once held only a library book with a taped spine. On a Sunday evening in late autumn, Amara stood in her own kitchen measuring dried anchovies and kelp into a pot of water. She was following instructions Daniel had written out for her by hand in English, rather than sent as a link because he said his mother's recipe never translated correctly out loud. The soup was for no particular occasion, only a Tuesday that happened to be his birthday. She had asked him once months earlier whether he still wanted it made, even though he no longer sat across from his father to eat it. He had said only that the soup was never really about his father to begin with. Daniel sat at her counter reading a report on his phone, unbothered by the silence, occasionally reaching over to adjust the burner without asking. It was the particular comfort of 2 people who had spent 6 years learning to trust each other one careful Tuesday at a time long before either of them called it anything else. Corinne called partway through the way she did most Sundays, and Amara put her on speaker while she stirred, letting her grandmother talk through the price of tomatoes at the Gary Farmers Market for a full 4 minutes before asking anything about Daniel at all. When Corinne finally did ask, she wanted to know only one thing, whether he still wrote things out by hand, and when Amara said yes, Corinne said that was a good sign in a man, better than anything a courtroom could prove. The kitchen smelled of sesame oil and a broth neither of them had grown up with in quite the same way, and the pot had started to hold a low, steady simmer that did not need watching anymore. Outside the window, the last of the daylight was going gray over a street that had nothing to do with Michigan Avenue or Gary, Indiana, or any of the counters either of them had once stood behind. Amara set 2 bowls on the counter instead of 1A. Habit, she had started the second year of making the soup herself. She folded 2 paper napkins into quarters, the way Corinne had taught her to fold a cloth handkerchief decades earlier, a gesture with no connection to Daniel's family at all. It had simply become, without either of them deciding it on purpose, the way the 2 of them folded everything at that counter now. Daniel noticed the way he noticed most things and said nothing about it. He only reached for his bowl with both hands the way his grandmother had taught him to receive anything from someone he respected, a habit 4 years of silence with his father had never managed to erase. On the counter beside the stove sat a small white envelope unopened that his mother had mailed him that week with no note inside. Beyond a folded bill, the same gesture she had used every year since he turned 21, regardless of whether he answered her calls. He had not decided yet whether to open it in front of Amara or wait until she went to bed, and for once, he let the question sit unresolved rather than rushing to settle it either way. There is a particular kind of proof that has nothing to do with a courtroom, the kind that shows up as 2 bowls on a counter instead of 1 or a folded napkin nobody asked for. It rarely arrives on the same afternoon as the vindication that makes the headlines, and it almost never announces itself the way a courtroom does with a verdict read aloud for everyone to hear. If someone has ever looked at you and decided out loud and in public exactly how little you were worth, what would it take for you to prove them wrong without ever needing to raise your voice to do it?